أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم والصلاة والسلام على أشرف المرسلين سيدنا محمد وعلى آله وأصحابه أجمعين. Assalamu alaikum wa rahmatullahi wa barakatuhu. Firstly, thank you and alhamdulillah for this opportunity. Last week, we looked at one of the legal maxims, one of the 5 fundamental or universal maxims, the 5 described as the qawaid al-fiqhiyya al-kulliyya. So these are universal maxims of Islamic jurisprudence. We discussed what maxims were, and we delved a bit into the first maxim, which was al-umur bi maqasidiha. Matters are judged by the purposes they fulfill, or matters are judged by their intents and objectives. And we looked at the different meanings and the implication of that maxim. Today we will be looking at the second maxim, or a second maxim, which states that al-yaqīn la yazūl bi-al-shakk. Certainty is not overruled by doubt. Very basically, what it means is certainty is not to be sacrificed for something we are less certain about. And even if we're not certain about evidence, we go with the greater evidence, or what we have less doubt over, as a preference to what we have greater doubt over or less certainty. This maxim, al-yaqīn la yazūl bi-al-shakk, is concerned about maximizing certainty whenever we have to make decisions. And so while it is a maxim that is really important in Islamic jurisprudence and Islamic law, it is useful and critical when arriving at legal rulings. It is also useful in everyday life. We know of the precautionary principle in a lot of decision making and impact assessment, where to err on the side of caution, to err on the side of more certainty. So we would hear things like a rabbit in the hand is better than 2 in the bush, or a bird in the hand is better than 2 in the bush. This issue of going with what we are more certain about. This maxim, al-yaqīn la yazūl bi-al-shakk, certainty is not overruled by doubt. And I'll be repeating it with the hope that before the end of today we've memorized it. So this maxim, al-yaqīn la yazūl bi-al-shakk, is established by scholars from a lot of evidence from the Quran and from the Sunnah. So every verse of the Quran that asks us to verify things, to get to the truth of the matter, to investigate, to ask those who know, to consult with others, to bring proof if what we say is truth. قُلْ هَاتُوا بُرْهَانَكُمْ إِن كُنتُمْ صَادِقِينَ. Allah says, bring your proof if what you say is true. To leave what we are in doubt of for what we are certain about. When people bring you any information that is potentially divisive, Allah says, investigate the matter, look into the matter. We have maxims that support this, that require us to ensure greater certainty when it comes to, say, punishments. For example, it is better to leave a guilty person free than to punish an innocent person. Part of the conditions for hudud and the very severe punishments are certainty. The Quran tells us to reflect, to think really carefully about what we believe, to question inherited beliefs, customary norms, things we got from our parents and forefathers, and cultural norms, assumptions, to be wary and avoid superstitions and rumor and guesswork and just claims. In Islamic finance, there's an avoidance of what is called gharar, just speculation. So this maxim, al-yaqīn la yazūl bi-al-shakk, that certainty is not overruled by doubt, is really a maxim that summarizes so much evidence from the Quran and Sunnah. So its meaning is understandably universally accepted by scholars of all schools of thought. I think just any common sense would also stand, but this is a common sense for some, but definitely established by evidence from the Quran and the Sunnah. And as we said, it is not saying that where there is no certainty, there's no decision making. Certainty is not overruled by doubt, is simply saying on the spectrum of certain to less certain to uncertain to completely uncertain, we should always go on the side of greater certainty. And so scholars would describe certain kinds of evidence as strong enough to give yaqīn, that is full certainty, absolute truth, no argument. But then where there's a lesser amount of evidence, they would describe that as being dhanni. In other words, the evidence is presumptive, it is most likely true, but it's not certain the way we would say for yaqīn. So if I saw a person, or we all see a person standing in front of us, and we say, this is Dr. Riza, he looks like Dr. Riza, and we all agree, then I'm not just seeing things. There's corroboration, there's evidence, we all know what he looks like, and this is Dr. Riza. If, however, all we heard was Dr. Riza's voice, as he said, Salamu alaikum, even though we are expecting him anytime now, and we've never come across somebody who has the same voice, that would most likely be Dr. Riza, but it's not the same level of certainty as where you see, the live person in front of you. And then when you find you don't see him, you don't hear his voice, but you see a car that's identical to his own parked outside, that's even less certain. And then it just becomes pure speculative when a car just passed by. I don't know whose car, it could be his. That's even, just guesstimates and completely guesswork. So what this maxim is basically saying is that in decision making, we go with the stronger one as a preference to the weaker evidence. So on the spectrum of certainty on one side to complete uncertainty on the other, we should always take evidence that is closer to the side of greater certainty, to follow the strongest argument, to follow the argument to its conclusion, to follow evidence, and not go with weaker evidence if we've got something stronger. The quality of evidence, of course, depends on different fields. So in law and jurisprudence, a judge may tell you there's the kind of evidence that would be described as truth beyond the shadow of doubt, or beyond any shadow of doubt. That's as certain as the judge needs to get. So if the punishment or the implications of the judgment are going to be really severe, they want the evidence to be beyond any shadow of doubt. If they can't get that quality of evidence, then they would most likely have to settle for evidence that is beyond reasonable doubt. So beyond reasonable doubt is not as strong as beyond any shadow of doubt, but it's good enough for certain judgments. But sometimes evidence beyond reasonable doubt may also not be available, and the judge would then go with the preponderance of the evidence. In other words, where the greater weight of the evidence seems to point to. And the judge would have to settle for the best evidence available to just guessing. Now, in some domains, some fields in mathematics, when you say this is true, it is easy to get evidence that is beyond a shadow of doubt. When it moves to other fields that are like economics, becomes a bit difficult. Engineering may be a bit easier. Medicine may be difficult depending on the field, depending on the patient. Economics a bit difficult. Politics even more difficult, until you get to more the other humanities and art, and whether a particular piece of art is actually good or not, how valuable is it or not valuable. For some, that's more subjective, less objective, but still you would have experts in that field congregating, having a consensus or greater majority taking one position or the other. So this maxim is simply saying you go for greater certainty, and it is not overruled by a position that is less certain. So al-yaqīn la yazūl bi-al-shakk, certainty is not overruled by doubt, is simply saying the stronger evidence is not to be put aside in favor of weaker evidence. This is important because in getting to the truth, in seeking truth, we have all sorts of obstacles. Our own preconceptions, our own biases, different types of biases, self-serving biases, confirmation biases. You've got a lot of books, a book on unconscious bias. Another good book I found interesting on this is Rolf Dobelli's The Art of Thinking Clearly, loaded with biases, assumptions. Adam Grant's book, Think. So a lot of writings on biases, for which in certain fields, al-yaqīn la yazūl bi-al-shakk, certainty is not overruled by doubt, is threatened by people's preconceptions. And so in scientific trials, we need double-blind experiments. We need experiments with controls. We need sample size big enough to give us a particular amount of certainty. And different fields, again, would differ in how much certainty they can arrive at. Say, for example, before you conclude that a particular medicine is actually medicinal and the effect is not just placebo, it's not just a belief that it would have a positive effect, because people in industrial pharmacy, those who are producing medicines, would say that over 70% of illnesses have been cured to up to 70%, or with up to 70% effectiveness, by things that really have no therapeutic value. So beliefs are really very strong. Once people believe this would cure me or this will not work, the psychosomatic, the relationship between the mind and the body is really powerful, that they have to come up with really clever experiments to be able to prove that this medicine actually works. So al-yaqīn la yazūl bi-al-shakk, that certainty is not overruled by doubt, is really asking us to go more with stronger evidence, to be more evidence-based in decision-making. So whatever that decision is. So yes, last time we looked at the maxim, al-umur bi-maqāsidiha, matters are judged by their objectives or the purposes that they fulfill. We need a greater level of certainty that A will lead to B, and not just it is possible that it could lead to B. We need certainty, not just the possibility of something happening. When we say harm should be eliminated in one of the maxims, which is the main one we will be looking at next time, harm to what? Who has measured the harm? Is it probability? How probable? We prefer something that has higher probability than something with lesser probability, and we will look at that more carefully. But it's also, therefore, a call to be more empirical, to have data as opposed to anecdotal evidence, to be more scientific in our gathering of evidence, to ensure that when we are assessing truth, we are able to commit to the search for truth, fi sabilillah, seeking Allah's pleasure, and doing it in a way in which we're not really pushing our own agenda. We're honestly trying to get to Allah's truth. And so when it comes to the role of human reasoning in assessing information in the search for truth, we find scholars give reasoning a very powerful position. But at the same time, if you recall, in the 5 major operational principles that go with the acronym TREES, trusting reason is number 1, respecting dissent, emphasizing social obligations, embracing maxims, and setting priorities. Immediately after trusting reasoning is respecting dissent. Why? Because reasoning is not perfect. It's useful. It's gotten us to where we are to a very great extent. We're very different from other creatures, alhamdulillah, in many significant ways due to reasoning. And reasoning is, according to the Quran, that thing that Allah expects us to use to decipher His ayat, His lessons, the signs towards His truth and the guidance He has given us. So reasoning, as we said before, is the crucible, the container that is to ponder over revelation and divine truths to arrive at the meaning and the implication and how these truths are to be applied and where they are to be applied. So when it comes to the search for truth, reasoning plays a very critical role in determining the authenticity of information. You know, when it comes to the authenticity of a hadith, it's not true because we believe it. It's not true and from the Prophet because we love the Prophet or because we love the hadith. It sounds really cool. We need evidence from the isnad. We need evidence supporting it from the matan, that is the chain of narrators, the content of the hadith, the reliability of the narrators, what we know about the biography of each of those narrators, and who learned from who. We need a level of historical criticism to verify the claims that this is an authentic hadith. We need to look at the character and the competences of those who narrated hadith in order to arrive at a conclusion that this hadith is sahih, is genuine, is reliable. And we look at the various kinds of evidence in each field for what constitutes proof. So the meaning, excuse me. So when we're looking at the role of reasoning, so reason plays an important role in identifying the authenticity of information. So, you know, has it survived history? Has the Quran survived history unchanged? Has a hadith survived history unchanged through word of mouth, through memorization, through written documentation? So this is critical. But since it's in human language and the Quran was revealed in Arabic, what is the meaning when we look at the rules of grammar, the meaning of these words? What is the meaning? What's the implication? And how sure are we? There again, certainty is not overruled by doubt. A meaning that is literal is usually preferable to an esoterical meaning or metaphorical meaning, unless the context dictates that, yes, this calls for a metaphorical meaning. And this applies to any language. So again, we need greater certainty, yaqīn la yazūl bi-al-shakk, when it comes to the meaning of terms. So in order to understand the meaning of a hadith, scholars would try and maximize certainty by looking at the language, by looking at the text's own context, what they call the sababul wurud, the context during which that hadith was narrated. You know, what was the Prophet talking about when he made a particular statement? But also to look at the context of that text in a holistic manner, not just what did this hadith say, but are there other hadiths? Are there other verses of Quran related to this topic before we conclude on what did the Prophet mean by this statement? And also the historical context of the Sahaba. How did they implement it? Were they clear about the meaning? And so al-yaqīn la yazūl bi-al-shakk, that certainty is not overruled by doubt, is really concerned about getting to the truth of the matter and looking for all evidence that can maximize certainty, so that when we say this verse of the Quran means this, or this hadith means that, we have the evidence for that position which we take. Reasoning plays a role in deciphering the wisdom behind commands and prohibitions and actions, the maqasid, identifying, what's the benefit of paying a debt? What's the problem with intoxication? What maqasid is each trying to protect? So reasoning plays a role there, and plays a role also in the application. So when a verse of the Quran is to be applied, reasoning would have to look at whether this is the kind of context in which that verse is applied. And we discussed this last time. Would the hudud punishments be applied in every case, or are there exceptions to that rule, and the deciphering of those exceptions? But it's not enough to just have evidence. We need to look at the quality of the evidence, not just the quantity, the quality of the evidence, the corroboration of various pieces of evidence. And it's that corroboration we are comparing with other pieces of evidence and saying which one is stronger. And so al-yaqīn la yazūl bi-al-shakk is really going in line with the stronger evidence. And this maxim, al-yaqīn la yazūl bi-al-shakk, we find it expressed in all the Islamic sciences, in the ulum al-Hadith, as we've already mentioned, in the ulum al-Quran, the sciences of the Quran, where scholars are trying to decipher the meaning of the text. What does the language mean? How did the Prophet understand it? What did these words mean during the Jahiliyyah period? And so you find a word having multiple meanings depending on the context. The word kitab can mean book, it can mean revelation, it can mean, it comes from the word kataba. Kataba can mean to write. Kataba ala nafsihi rahma means to decree. Kutiba alaykum siyam is to prescribe or to decree. The word kafir, kufur, kuffar, in one context could mean a farmer, somebody who covers his seeds with soil. Kafara could mean to be ungrateful. It could mean to deny a truth. It could mean to cover up truth. So it could just describe ingratitude. The context would tell us which meaning applies to which particular context and what conditions apply to each word. Al-yaqīn la yazūl bi-al-shakk, the certainty overruled by doubt, plays a very critical role in determining the fundamentals of the religion of Islam, the ma'lūm min ad-dīn bid-darūra. And so you would find, because scholars are more certain about both the authenticity of the Quran and the authenticity of multiple chained hadith that are described as mutawatira. These are hadith with so many independent chains corroborating each other that it is difficult to describe the truth of that hadith as probably true. They are sure this is ilm al-yaqīn. We are certain about it, as we could be certain about many other pieces of information that have that type of evidence. So those fundamentals of the deen would only be established by the kind of evidence described by scholars as qat'i thubut. Qat'i thubut means we are certain, definitively certain, absolutely certain about the authenticity and the source of the information. So that they would use to describe, say, the Quran or a hadith that all scholars agree these are mutawatir hadith. And some scholars would say those are hadith that have up to 10 to 30 or 50, or some would say 70 chains of narrators, or where there's so, the preponderance, the amount of chains of this hadith make it impossible that this could be a lie or it could be fabricated. But it's not enough for evidence to come from the Quran or from hadith mutawatir. The meaning of that verse of the Quran also has to be categorically clear, explicitly certain, no ambiguity, no difference of opinion regarding what it means. And so once you've got those two requirements, that it is qat'i thubut and qat'i dilala, that we are certain about the authenticity and certain about the meaning and the implications of that verse, that truth becomes the fundamental of the religion. To deny it would be denying a fundamental of the religion, which, if certain conditions are met, could constitute an act of kufr or excommunication from the religion. But it requires that degree of certainty. Certainty can be dangerous when people claim they are certain and the evidence has not reached the quality that should give certainty. And so intellectual humility is critical for every Muslim. Certainty is something that is rare in any field where people change positions as more knowledge is discovered. And so while some would be very certain about the meaning and implications of a verse of the Quran that is presenting a scientific fact or natural phenomena, you will find some scholars a bit hesitant and concerned about reading meaning into the text, especially when that is coming from a field like science that never stops searching and so never stops changing its position on things. And that's part of its strength. But that's also why scholars would want to be very clear regarding what's a fundamental of the deen that comes from qat'i thubut, qat'i dilala, what we are certain about regarding the authenticity and what we're certain about regarding the meaning and implications, and distinguishing that from evidence that is dhanni. Dhanni means there's a degree of presumption, there's a degree of speculation, and so there's a valid reason for differing opinions. Scholars see a particular verse in different ways, and the meaning is a product of ijtihad, it's juristic reasoning. And one juristic reasoning doesn't overrule another juristic reasoning, even if you have many scholars behind one position, so long as reasoning could come up with an alternative meaning based on the text and the rules of interpretation. The scholars would respect the diversity of opinions and recognize that those scholars who hold one view belong to a particular madhab or belong to a particular school of thought or school of law compared to others. And this applies to topics like aqeedah, fundamental, or what I call this, beliefs and creed. There are those things in aqeedah that are fundamental. They are the usul of aqeedah, not the furu, not the secondary or subsidiary matters, the fundamentals of aqeedah that everybody agrees on, and there's no difference of opinion. But there's a lot of debate on many other areas of secondary importance, those things that are not categorical in the Quran and Sunnah. And so again, al-yaqīn la yazūl bi-al-shakk, certainty is not overruled by doubt, should let us know that once we hold on to the fundamentals of the deen, and we should not allow the doubt that exists in areas of ijtihad and juristic reasoning to undermine our recognition of each other as Muslims or the brotherhood that keeps us together. Ijtihad or juristic reasoning is an exercise that is guided by the field of usul al-fiqh, of qawaid al-fiqhiyya, and the maqasid of Sharia. So juristic reasoning requires evidence. It's not just because Imam Malik said so, or Imam Abu Hanifa or Shafi or this scholar or that scholar says something that it is true. Each scholar has to bring evidence for their position. And so we find in the madhabs, the schools of thought, actually the fundamental difference in the madhabs is the level of certainty they give different forms of evidence. And so you would find, for example, in the Maliki madhab, something that is very unique about the Maliki madhab is the kind of weight that Imam Malik and the Malikis give to Amal Ahl al-Madina, the practice or the praxis of the people of Medina when it comes to other forms of evidence. So in Maliki fiqh, the practice of the people of Medina during the time of Malik bin Anas, those practices that were inherited by that generation, because Imam Malik lived at a time when his teachers were students of the Sahaba. So when he sees what his teachers were doing and they were doing something different from what was in a single chained hadith, or what they call a hadith ahad, one that had fewer chains, not enough to be mutawatir, Malik would give Amal Ahl al-Madina greater priority compared to others. So every madhab had its own difference. The early Shafi school, for example, was very suspicious of maslaha, al-masali al-mursala, in particular consideration of public interest, istihsan, juristic preference, and urf, local custom, whereas the Maliki madhab recognized urf, along with the Hanafi madhab. They gave greater weight to urf. Hanbali school gave a lot of weight to singular chain hadith compared to other schools, including the Shafi and Maliki. So the main difference between madhabs is really which tools, which sources of evidence they consider stronger, and how they arrange the hierarchy of evidence. We find this maxim, al-yaqīn la yazūl bi-al-shakk, being very critical when it comes to determining which fatwa is stronger than another fatwa. And so the scholars would say, for example, that when evidence has been harmonized, when all evidence on a particular issue has been brought and harmonized, no more contradictions, the fatwa that's a product of harmonized evidence is stronger than a fatwa that is based on tarjih, that is based on preference to this evidence and dropping other evidence that is also credible. So where all the evidence is harmonized, it's described as jam'. So it's described as having been reconciled. So you don't have conflicting evidence, you don't have ta'arud, because a competent scholar has been able to reconcile all the relevant evidence, to put the evidence as a like a jigsaw puzzle. Every piece has its place, and every piece of evidence has been respected and acknowledged. So that's called jam'. Whereas if the evidence is put aside because some scholar prefers some other evidence to another, either because they consider it stronger or whatever their reasoning is, that would be called tarjih. It's preferring one to the other, or eliminating some evidence and going with another, which is a method that is not as strong as where it's been harmonized. Also, some would resort to abrogation and the claim that this verse has been abrogated, or this hadith has been abrogated by another. Anytime you hear evidence has been abrogated or evidence has been eliminated, and it's coming, and the evidence is Quran or hadith that is sahih, etc., it usually means an incomplete fatwa. It usually means the person was not able to reconcile, and that it is an imperfect management of evidence. It may still be true, because after somebody has reconciled, they may actually end up with the same opinion of somebody who eliminated some evidence in preference to something else. But this is why triangulation in ijtihad is really critical. The use of both usul al-fiqh and the qawaid al-fiqhiyya and the maqasid al-sharia. One fundamental difference between bid'ah, an innovation or heretical innovation, and ijtihad, they all result in new opinions, new rulings, but one is appreciated, ijtihad is appreciated because it follows the rules of usul to come up with a new ruling, whereas a bid'ah does not respect the rulings. It ends up making permissible what is prohibited, or making prohibited what is permissible, because it doesn't respect the rules of interpretation or the rules of ijtihad, qawaid, and maqasid. This maxim, al-yaqīn la yazūl bi-al-shakk, certainty is not overruled by doubt, is a maxim that encourages us to move away from speculation, to prefer qualitative evidence to just quantity of evidence, to recognize ijtihad does not override ijtihad. We should assess the evidence. It also directs us in recognizing the default rulings of Sharia, the legal presumptions, also called the istiṣḥāb. Istiṣḥāb is the law of defaults, if I put it in simple English. It's the it determines the starting point of every fatwa. So it tells us who the burden of proof rests on, who should provide evidence. So when we say, for example, somebody is innocent until proven guilty, we are already giving a ruling that this person is innocent until proven guilty. Consequently, when a case goes to court and somebody says, Mr. A stole Mr. B's phone, we assume innocence as the starting point. Guilt has to be proven. And so the burden is on the plaintiff, the person accusing the person who is claimed to have stolen. It's you who has to prove that your phone was stolen. It's not for the person accused to prove they didn't steal your phone. They just need to swear or take an oath that they didn't steal, but the burden of providing evidence is on the side of those who claim somebody was guilty. So this leads us to a number of defaults, a number of legal presumptions in Sharia. So we have a number of defaults, and the way you find it in the fiqh books in Arabic, they would say things like al-asl, bara'atu dhimma, or al-asl, ma kana ala ma kana, al-asl baqa ma kana ala ma kana, al-asl. So al-asl means the original position, the starting point, the norm, the priority, the more certain position, the stronger evidence. So when it says al-asl fil ashya al-ibaha, that the asl of things is permissibility, it means the priority, the starting point, the default judgment, the legal presumption is that everything is permissible except what is prohibited. And so when that is the default position in Sharia, then it is for the person who is saying it is haram to be the one who brings evidence, not the person who is saying it's halal, because Sharia has already given its own basis from the Quran, from the Sunnah. So just as the certainty is not, just like al-yaqīn la yazūl bi-al-shakk, certainty is not overruled by doubt, these maxims are sub-maxims from this major maxim, certainty is not overruled by doubt. And each one of them, and I'll go through them quickly, each one of them is established by verses of the Quran and Hadith. Some of them actually, as you will find for many of these maxims, they're actually paraphrasing, sometimes nearly word for word translations of Hadith or verses of the Quran, but mainly Hadith. So one of them takes it, as we've already mentioned, that people are innocent until proven guilty. So the legal presumption, the default law in Sharia is that every human being is innocent of crime, is innocent of sin until proven guilty. And so the burden of proof is on the person who is claiming somebody is not innocent. The presumption that the status quo remains as it was unless there's evidence to the contrary, you know. So when somebody performs ablution, goes to pray, is not sure whether they still have their ablution or not. Are you sure you performed ablution? Yes, I am certain about that. Are you sure you broke your ablution? No, I'm doubtful. I might have, I might not have. That doubt will not overrule the position of certainty. So we go back to the status quo that we are more certain about. The issues surrounding marriage, is somebody married or not? Well, if we have no evidence you are married, if yesterday you were not married, if last year you were not married, we assume you're not married until we have evidence that you are married. Meanwhile, if we do know you got married 7 years ago, we assume you are still married unless we have evidence of a divorce. And so even when there's a doubt, look, the husband said something, it could mean divorce, it could mean it's not a divorce. How should we take it? Well, before he said it, the assumption was that they were married. So we're not going to undermine and overrule the earlier position, which we were certain about, by a position of doubt. Another maxim is the bara'atu dhimma, the freedom from responsibility, that people are assumed to be free from responsibility unless there's evidence that they are responsible. So you don't, accuse people for not taking care of your stuff if they were not legally responsible for taking care of your stuff. They don't have that default ruling on them. People are free from responsibility unless there's evidence that they are responsible. So you don't say, where's my son? He was in the playground and I accuse you for doing anything if I didn't tell you to watch over my son or daughter or property. There's also freedom from oppression, freedom from bondage, that people are born free. You need evidence to justify imprisoning them or restricting their freedoms. When it comes to language, it is assumed that a command, when the Quran or Sunnah or when there's an instruction, that it is a command, unless there's evidence that it is not a command, or that the a negation, a nahi, saying something should not be done, would be assumed to be a prohibition unless there's evidence to the contrary. In language, the literal meaning of statements is assumed to be their meaning unless the context makes it clear that a metaphorical meaning, or the way the language is used tells us a metaphorical meaning is to be assumed. There's the default law or assumption that everything is permissible except what is prohibited. So in the yaqīn la yazūl bi-al-shakk, certainty is not overruled by doubt. We are more certain that everything is permissible than we are that everything is prohibited. So the general rule is everything is permissible unless you have evidence to make exceptions to that rule. We see that in the Garden of Eden. Allah says to Adam and Hawa, eat whatever you want, eat and drink of anything you want in this garden, with the exception. So he didn't have to mention all that is permissible, but he did mention the exceptions. And we find, so is it permissible for Muslims to eat a kangaroo? Everything is permissible except what is prohibited. Would it be permissible to eat a new fruit called durian? Everything is permissible except what is prohibited. Permissibility is the default. It's the person saying something is haram that needs to bring evidence, because they are then saying there's a sin. If you say there's a sin for doing something, or Allah will punish or may punish an action, you need evidence. You can't just be speaking in God's name without evidence from the word of Allah. Another legal presumption that goes with this certainty is not overruled by doubt is the purity of things and substances, that all beings are pure, that all substances are pure, unless there's evidence to the contrary. So if we have a liquid that spills on your shirt, the assumption is it is pure unless there's evidence to the contrary. So general rule about things is everything is pure. There's a legal presumption that justice implies equality in treatment unless there's evidence to the contrary. So when it comes to be just among people, it means treat them equally, no discrimination based on age, based on race, based on social structure or culture, based on gender. Whatever is haram to all alike. Whatever is wajib, compulsory, is compulsory for all alike. We need evidence to make an exception. So when you look at, say, for example, men and women in Islam, Islam assumes they are both equal in their humanity and their responsibilities in the deen and the prohibitions. Alcohol is prohibited for men and women, and pork is prohibited for women and men, young and old. So when we look at the acts of ibadah, they are the same for men and women, with the exception of a few. When we look at the mu'amalat and interpersonal relations, the haram and the fard and wajib are the same for men and women, with the exception of a few. When it comes to aqidah, what should a Muslim man believe is identical with what should a Muslim woman believe. When it comes to laws and punishments and rewards, there's no greater punishment for a man compared to a woman, or vice versa. They are equal before the law, except where there's evidence for exceptions. Another maxim states that what is haram is haram for, what is harmful is haram. That harm is haram by default. I would not be surprised if these two words have some kind of linguistic origin that is similar. But whatever is harmful, physically harmful, economically harmful, harmful to individuals, harmful to communities, psychologically harmful, harmful to people's honor and dignity, politically harmful, emotionally harmful. The moment something is harmful, it is haram by default. So you can't justify haram unless you have evidence that it is the lesser evil and you are forced to choose between one, which we will look at more carefully next time. When you have a contract, business contract, it is assumed that there's a duty to fulfill that contract unless there's evidence that the duty has been fulfilled or that the contract has been broken. So once there's a contract, there's an obligation. There's a default assumption that there's an obligation to fulfill your contract. Once you've been paid to do a particular job, Sharia considers you bound by that contract unless there's evidence to the contrary. The sacredness of life, all life, you can't just take the life of a living thing for no reason. The default is that life is sacred. The default regarding taking of lives is haram. So you have to have evidence for killing a snake. You can't, I mean, if you're afraid it will hurt, well, you got a reason. But you can't just go into the bush and just kill any snake for no reason whatsoever. The default is we should actually save living things as khulafa. When it comes to devotional worship, acts of worship, many scholars, this is an area where scholars would generally differ, but many would say al-asl, the legal presumption in devotional worship is tawaqquf, which means to put a pause, to stop. It's not saying it's haram, it's not saying it's halal, it's just saying pause until you can find evidence for a particular position. And some of that evidence may come from the practice of Sahaba, from maslaha, public interest would allow an act of ibadah to be regulated due to crowd, for example, during Hajj, etc. So to conclude on these, it is important to know not just certainty is not overruled by doubt, it is important to remember the defaults that are the sub-maxims of this major maxim that is concerned with maximizing certainty. So this is the maxim for maximizing certainty. Al-yaqīn la yazūl bi-al-shakk. Certainty is not overruled by doubt. We should be more truth-oriented. We should be more evidence-based in decision-making, in programs, in choice decision-making. And the onus of proof is on whoever is claiming. No evidence is not itself evidence. Not having evidence from Quran and Sunnah is not evidence that something is haram. It just describes that it wasn't done at the time of the Prophet. So just saying it's not in the Quran, it's not in the Sunnah, the default of something that is in mu'amalat, for example, is permissible. So when people say, well, this is haram because we don't have any evidence for its prohibition, that's an inverting, you're turning upside down the maxim of everything is permissible in interpersonal relations, in worldly transactions, in customary affairs, except if there's evidence to the contrary. So when somebody says, bring proof that this is permissible, you just need proof of the default position that everything is permissible according to the Quran and Sunnah, unless there is evidence for a prohibition. And evidence for prohibition is not that it wasn't done. That doesn't make something haram. It wasn't done just means it wasn't done. It's just descriptive. It's not prescribing a prohibition. So I'll stop there. There are many areas of application for this maxim. Every field that requires decision-making, weighing of evidence, in medicine, what would be stronger evidence in economics, in politics, in law, in every profession, you would say there's where we could get greater certainty. Is it to ask professionals of that field regarding vaccine hesitancy and effectiveness, or do we go on social media? Do we go to the professional regarding efficacy of a particular medicine? Who are the experts in each field? That may give us greater certainty instead of doubt. So I'll stop there on this maxim. Certainty is not overruled by doubt. And Thank you very much. Sorry for having taken so much time. Assalamu alaikum. Riyadh?
Yes, thank you very much for that, Sheikh. If there are any questions, feel free to use the chat, or there's chat both on YouTube as well as on Zoom. So you can use your chat. If you would like to speak, then please put your hand up. Just raise your hand and I will unmute you, and we can do that. So Sheikh, this whole story of permissible against, I say the position of being, firstly, what is accepted, and then that for certainty, as opposed to when they have an issue of it's being some sort of doubt. What happens in a situation when there is only doubt? So, well, I wouldn't say only doubt, but more so when one person believes that this is what it says, their interpretation is that it's certain, and another person's interpretation, well, there's some sort of doubt. I mean, how do we try to resolve something like that?
So when it comes to decision making, and there are two positions that are equally doubtful, there's a respect for that reality that we're not sure, that wallahu alam, Allah knows best. And what scholars would try to do is then to try and see how they can maximize certainty. Is there any other source of information? So say, for example, a position of scholars where I live, which is predominantly Maliki, and scholars here would consider that dog saliva is not najas. Okay, dog saliva is not najas. Whereas you'd find, say, the Shafi'i scholars and some of the others would say, no, dog saliva is najas. If a dog licks your hand, you must wash your hand before you go to pray. Otherwise, it's as impure as urine, for example. When you look at the evidence for it, the evidence, according to some, is a hadith where the Prophet said, if a dog licks a bowl, wash that bowl 7 times, and one of those times with sand. So that's one interpretation, that therefore dog saliva is not just because you have to wash the bowl this number of times. The Malikis stick with the default position that everything is pure except if there's evidence to the contrary, and they consider that hadith as being applied to just a bowl. That's what it says you should, or not if it licks your hand. And we need more evidence. And so the Malikis would look at the fact that hunting dogs can go and catch a rabbit and there's no washing of the rabbit this number of times. They would look at the fact that washing your feet in wudu is not because your feet are impure in the physical sense. So basically what you find scholars doing is moving into other areas to look for other evidence that could tilt the scales in one direction. But at the end, as you said, there are positions where you would say, honestly, I am confused. I'm not sure what to do. Then you may want to trust somebody. So just like in a medical case, one doctor says you need an operation, another one says you don't need an operation. You probably want to consult a few more. And at the end of the day, your actions will be judged by your intentions. Allahu alam.
Thank you very much for that, Sheikh. So I see there was one question, but I think you answered that in the chat. Any other questions? Please feel free to raise your hand or put it in the chat. Let me look at YouTube here. I'm not seeing anything on YouTube. So, Sheikh, I think you did a very good job, because I think they all quite understand what you were saying.
Alhamdulillah. Alhamdulillah.
Alhamdulillah. Yeah,
I hope
no
it's that
one.
good and not a self-serving bias. Alhamdulillah.
Here we go. What is the criteria for defining something as a bid'ah?
Okay. Bid'ah is usually what you'd call a counterfeit in religion. Just like counterfeit money. It looks like the original, it claims to be original, but it's fake. It is not established by any evidence. Scholars differ in their criteria for bid'ah. So some scholars such as Ibn Taymiyyah, Imam Shatibi, and a number of those scholars would, coming from particularly the early Maliki scholars and the Hanbali scholars generally, they would consider as bid'ah anything in the area of ibadah, acts of worship that were not done by the Prophet and his companions. So for them, the question simply is, if you do any act of ibadah, any act of worship, they would simply ask, did the Prophet do what you're doing? If you say no, they say it's bid'ah, then stop. They're against excess baggage in the religion. So if you get together and do dhikr, for example, after prayer, they say, did the Prophet do that? And you say no, they would say it's bid'ah. If you, anything you do. Whereas other scholars, the later Maliki scholars, the Hanafi and the Shafi scholars, considered bid'ah as possibly being good or bad, but for bid'ah to be bad as an innovation, it had to conflict with evidence. So they viewed that even in acts of worship, once you can establish evidence from the Quran, the Sunnah, qiyas, or reasoning by analogy, or maslaha, public interest. So we find Uthman doing a second adhan, you know, to, at the time of the Prophet, it was only one adhan. But because he did a second adhan so that more people could have time to come and catch the khutbah, or Umar radiallahu anhu, encouraging social cohesion and people praying together for Taraweeh, when during the time of the Prophet, most of Taraweeh, and during the time of Abu Bakr, everybody just did their own at home or in the mosque. So you do find for some, the simple criteria is, did the Prophet and his Sahaba do it or not? If you say no, they say it's prohibited. Whereas for other scholars, it's not enough that the Prophet and Sahaba didn't do it. So like Mawlud and Nabi or dhikr in congregation, they would say it's encouraged to do things in congregation. It's rewarding to do things in congregation. And so they would have no problem with that. So this is a topic of differing opinions, but I think it's important to recognize that the two opinions, and there are many opinions in between these two, that the opinions are products of ijtihad. And as products of ijtihad, we respect the diversity of views of scholars when it comes to issues of ijtihad, and not allow the ijtihad position of scholars to make us break our brotherhood and unity of faith just because of an ijtihadi position of some scholars. So if you're looking for those who say the Ibn Taymiyyah position, you will find hundreds of scholars holding that opinion. If you look for the Shafi opinion, it's like the one of al-Isra bin Abdul Salam, you know, where he classified some forms of bid'ah, fard, some are mustahab, some are mubah, some are makruh, some are haram, you know, and there's good and bad bid'ah. There are hundreds, actually thousands of scholars holding each opinion. So let's be careful when we meet issue of difference of opinion. Let's respect the dissent. Let's have the intellectual humility to recognize that scholars greater than ourselves have held some of these opinions. And I may prefer my own, but I respect your right to hold your opinion as a Muslim. Wallahu alam.
That's good. There's another question here about celebrating birthdays. Sheikh, what's your opinion on celebrating birthdays?
Birthdays, just like Independence Day celebration, belong to the category of mu'amalat. Mu'amalat means social, interpersonal, worldly, mundane, dunya affairs. They are also more customary norms. Some customs celebrate birthdays. Some cultures consider birthdays important. Others less important. Others have, no recognition of those. So the general rule on customary matters, what they call adat, is that everything is permissible except what is prohibited. So once you have evidence that this is a Western cultural norm, or an East African or Kenyan, or, you pick every ethnic group you want, whether it's English or Irish, whether it's Scandinavian or Russian, whether it is Swahili, Mandingo, Hausa, Fulani, Mexican, Indian, Pakistani, the moment, or Japanese, wherever it's coming from, the moment it is a customary practice of a people, the default position of Sharia is it is permissible, unless there's something haram related or associated with it. So if somebody is going to celebrate their birthdays and drink alcohol, the alcohol is the haram part, not the fact that they have birthdays. So generally what you find is people's customs are considered not just permissible, but actually respected. When we come to the fifth maxim, the fifth of the universal maxims, al-ada muhakkama, that custom has the weight of law in Sharia, we will look at this more carefully and look at various customary norms that people had that the Prophet respected, and sometimes even imported. As you would know, in the Battle of Khandaq, there was a customary military strategy of Persia that Salman al-Farisi suggested. Salman al-Farisi was a companion who had embraced Islam. He had originally come from Persia, and he brought all sorts of strategies of digging trenches, catapults or mangonels, etc. And the Prophet adopted these, even though these customs were originally non-Muslims, but they didn't conflict with anything in the Sharia. So birthday celebrations, in my humble understanding, if you go with what all scholars accept, that this is a customary practice, it's where it becomes a religious activity, where you say something like celebrating Christmas. That's where you will find most Muslims having a problem, because this is copying people in an act that they have turned into ibadah. So it's like their mawlud of Isa alayhi salam. So when it comes, however, to everyday birthday celebrations that people of a particular custom have, Independence Day celebration, like the recognizing or commemorating the independence from some colonial rule, or anniversary or graduation ceremony or matriculation or convocation, any form of these acts are considered halal by default, permissible. Evidence is required to make them haram, and Allah knows best.
Thank you very much for that, Sheikh. So someone is asking for some of the reading references for advanced preparation for the next class. So I guess you can share that.
There is the material. I don't know if the person answering is part of the course that was done last weekend. So there is some reading material that's very useful there. Otherwise, I would highly recommend if you search for Living Islam with Purpose. Living Islam with Purpose by Dr. Umar Farooq Abdullah of the Nawawi Foundation. He has a wonderful, it's about 50 pages, but it is worth reading it 5 times, to be honest. So yeah, he has a good discussion there on embracing maxims, and he discusses each of these maxims in a very practical manner. You could search online for Islamic legal maxims, or if you start searching and you write harm must be eliminated. So in preparation for next class, we will be looking at ad-darar yazūl. Harm must be eliminated, ad-darar yazūl, and seeing both the prevention of harm, the stopping of harm after it has commenced, and the implications of choosing greater or lesser evil when a harm cannot be avoided or cannot be completely avoided. So the next one, inshallah, will be looking at ad-darar yazūl, that harm must be eliminated, harm must be removed, whatever the nature of that harm.
Good. And then there's one question again. What is the ruling on contributing money to support the burial expenses of non-Muslims?
Many, you know, when you look at the Sahaba, the Quran is full of exhortations about respect your parents, be dutiful to your parents. Most of the parents of Sahaba were non-Muslims. Let's remember that. So all these hadith on be good to your parents that the Prophet was telling the Muslims, a lot of the parents were actually not Muslims. So number one. Number two, when it comes to a non-Muslim, if your parent was a non-Muslim, who else is expected to dig the grave and pay for the burial expenses and the transport? It's a fardu kifaya for Muslims to bury the dead. And if nobody is burying the dead, the Prophet would bury the dead. The Prophet never left a battlefield where non-Muslims were dead, were left abandoned for the vultures and the hyenas, etc. And so Muslims would bury. What a point I'm making is the actual digging, the actual burial. So contributing money is nothing compared to the actual doing. So taking it back to the principles we've just discussed, certainty is not overruled by doubt. Contributing to burial is not an involvement in the ibadah acts of worship. It is contributing money to the family who will be hosting people. They will be paying for space in a cemetery. They would be paying for the transportation, and depends on the custom or the culture of the people. So when it comes to supporting a family, and so you will find people in an office putting money together to support the burial expenses, you're actually helping your colleague. You're not helping the dead. The dead's dead and gone. Their soul is with Allah, and Allah is the wisest and decides what to do. So you're not contributing to anything to do with the hereafter of the body. You're actually helping the family who is alive manage their bereavement. In some places, they have so many visitors coming. Sometimes the visitors are poor, but they are relatives. Depends on the society, and some feeding. So in many places, neighbors and extended family members and friends would send food, send water, something to make it easier for the family to bear the loss. So because this is a financial contribution, it belongs to mu'amalat, and in mu'amalat, everything is permissible except what is prohibited. So it is halal to contribute to the burial expenses of a non-Muslim, especially if it's a relative. There's an obligation to support that as best as you can. Where you may have objections and have some problems is where it's also going to be used for purchasing alcohol. It's also going to be used for this and that, where you may want to be more specific regarding what you are supporting. So this is to support the transport, or this is supposed to support the feeding, but it's a mu'amalat and everything is permissible except what is prohibited.
Great. So we have another question here. Can these maxims be used by a layperson in matters of deen without seeking clarification of scholarly and fiqh opinion of such matters, as there would be full discussion on how and why maxims are applied by other usul and nusus?
This is a good question. This was also raised last week when we discussed the maxim number 1, al-umur bi-maqasidiha. And it is important to remember none of these maxims stands in isolation of others, number 1. None of these maxims stands in isolation of other verses of the Quran or Hadith. So when we say, for example, al-aslu fil ashya al-ibaha, that everything, the legal premise, the default ruling of Sharia is that everything is permissible except what is prohibited, that prohibition may come from evidence from the Quran or from a Hadith or from qiyas. Reasoning by analogy, it may come from evidence of it being contrary to public interest. It may come from evidence of it being actually harmful. So saddu zariya, preclusion or blocking the means to a harm may be employed by a scholar. So this is not, these maxims don't give people the qualification to be scholars in any field. Every field has its maxims, but just knowing the maxims doesn't create scholarship. And so, yes, and I think as is implied by the question, For a layperson is lay because you are a layperson. And if you recognize that, then definitely what a maxim could do is help you question a legal position to find out whether that legal position was actually meant for your context or not. When somebody says, oh, this is medicine that you should take, and it's a scholar who is saying this is good medicine, but you know what, certainty is not overruled by doubt. I'd rather listen to a medical specialist than listening to somebody who says, I should take this medicine for my cancer or for some serious illness. So there again, it is useful for lay people, but a lay person should also understand you ask scholarly people. And if you're not satisfied with one scholar, look for another scholar. In medicine, because you're not satisfied with one doctor, doesn't mean you start self-medication. You look for another doctor to advise, because that is greater certainty than your own judgment. Allahu alam.
Great, and I think that the whole purpose as well is that it gives us tools as a layperson to better understand what's out there and some of the controversial issues. But then again, clarification. Okay, so we have another question. What is the position on shaking hands with female colleagues at the workplace?
So back again to our maxims. Shaking hands is not an act of ibadah. It belongs to mu'amalat. And so everything is permissible except what is prohibited. Now, this is where for many scholars, there is clear enough evidence that it is prohibited. So even if the starting point is everything is permissible except what is prohibited, they will say, we have clear hadith that make it prohibited. The Prophet ﷺ is reported to have said, it is better for you to have your hands pierced with red hot needles than touch a woman who is haram to you. Now, and for some, that's enough evidence for a prohibition. Another evidence that is sometimes brought is the fact that the Prophet said in a verse, I do not shake hands with women. But you will find, for example, the Maliki scholars in Sudan and some parts of North Africa have no problem with men and women shaking hands in a purely platonic relationship where it is not qurbil zina, because one of the other pieces of evidence is la taqrabu zina, do not do something that leads to zina. So all of these verses of the Quran and Hadith are used to restrict the general permissibility of shaking hands with anybody, Muslim, non-Muslim, men, women, etc., etc. However, and you can read more about this, Yusuf al-Qaradawi has written a book on this subject area. An article on it online, shaking hands with women or with non-mahram women. And basically one of the points that he and other scholars who hold that position make is the default position that everything is halal except what is haram, that shaking hands is halal except what is haram, that the evidence to say haram is not strong enough, because haram means Allah will punish. Haram doesn't just mean it's not a good idea. Haram doesn't mean it's makruh, disliked. Haram means it is prohibited. These scholars would say, if definitely you will have feelings and this will lead to zina, they will all agree it is haram. But the hadith where the word lumps or mas, which means touch, is used, they cite the fact that Ibn Abbas says everywhere that word is used in the Quran or hadith, it is used as a euphemism for sexual relations. In other words, the hadith that says, whoever touches a woman that is not halal, it is better for him to pierce his hands with red hot needles. Another one, pour molten lead into his ear, and various hadith showing punishment, say that these are hadith that are talking about zina. When the word is used, Maryam, peace be upon her, in the Quran, وَلَمْ يَمْسَسْنِي بَشَرًا, how can I have a son? She's asking the angel, when no man has touched me. Touch there is not physical, just touched my hand or touched. It means nobody has been sexually intimate. When the Quran says you do not come near unto your wives or don't touch your wives when they are in their monthly periods, it's not just you can't physically touch. It's saying you can't have sexual intimacy. And so all the evidence that is used to say it is haram to touch women have been interpreted by these scholars to mean it's prohibiting sexual intimacy or things that lead to, where there's a greater certainty, this will lead to sexual intimacy, and that would be qurbil zina, that would be leading to zina and would be prohibited. But if in a custom or in a particular context, shaking hands with a woman would not mean anything, maybe to collect a certificate, maybe it's a casual greeting in a custom, you would find these scholars making it clear that there is no prohibition from the Quran and the Sunnah that goes contrary to the default ruling that everything is permissible except what is prohibited. Having said that, and I think next time we'll be looking at ad-darar yuzal, but after that we'll be looking at al-mashaqqa tajlibu at-taysir, those situations where even the scholars who consider it haram would regard certain contexts as permitting this, and we will come to that. But there is a difference of opinion among scholars. It is products of ijtihad because there's no categorical evidence that is on this, and we respect the diversity of opinions, and Allah knows best.
Thank you, Sheikh. So we have one question here, and this will be the last question we'll be taking for today because we have 5 more minutes before we end the session. So the last question here is, everything is permissible until proven prohibited. Is that applicable for meats that need to be halal? Then what is the merit of zabiha if is the maxim stands enough?
Okay. If you remember something we said earlier about these maxims, the maxims are representing the norm, the general rule. There are always exceptions to the general rule. The maxim is presenting the legal presumption, the default ruling, the priority, the starting point, the position of greater certainty. So it's the general rule. There would definitely be exceptions. And so on the issue of meats or luhum, you would find some scholars actually say al-asl fil luhum al-haram, that the legal premise regarding meat is that it is haram. And if you say, like, how did they get to that conclusion? They would say, well, of all the animals in the world that you can eat, herbivores, omnivores, carnivores, if the carnivorous animals are so many and prohibited, then, and so that's one, the species of the animal. But then if you look at the different ways in which animals can be killed, there's really just one way that is permissible, by slaughtering the animal. Of course, if it's a hunter who has to shoot, that is also permissible. But of all the different ways of killing an animal, there are really many, many ways of haram, by strangling the animal, by clubbing it and beating it to death, by cutting it from another part of the body other than slaughtering the neck, by throwing the animal off a cliff, by piercing the animal from multiple sides with spears. And, you know, there are many ways of killing, but only one is permissible. So if you're going to make a rule, the rule would easily be that the rule is prohibition, except if you have got evidence of the permissibility. So the general premise that everything is permissible except what is prohibited, when it comes to meats, for example, in the Maliki school, they look at most animals as permissible strictly unless it is dog. Actually, there's a debate on dogs. There's a debate on carnivorous animals because it's an ahad hadith that conflicts with some of the Amal Ahl al-Madinah. Malik recognizes, and anybody interested in this subject can read Bidayat al-Mujtahid by Ibn Rushd. It's the Distinguished Jurist Primer. It's available in English, 2 volumes, and look at the subject of meat. So for Maliki school, the only animal categorically, the species of animal categorically prohibited is pig, the flesh of pig, you know, meat from swine. that is what is categorically prohibited. Carnivorous animals are makruh, disliked, but not haram. And so when it comes to the species, the Malikis will still insist that most animals belong to halal category, because makruh also belongs to halal category, in that haram means there's a sin, there's no sin on makruh. Once it is food of Ahl al-Kitab, people of the book, the general position of the Maliki and the Hanbali view is, if you are not sure, then mention Allah's name and eat. And this is because some came to the Prophet ﷺ not sure about some meat that was given to them by the Bedouins, Arabs, and they asked, and the Prophet ﷺ just said, mention Allah's name and eat. So some take that line of argument. Others insist, no, it must be slaughtered with Bismillah in Islamic rules of slaughtering. So this is an area where some scholars have differed, but everything is permissible unless proven prohibited. For the Malikis, the prohibitions are very few, whereas for others, all carnivorous animals are prohibited. So in every madhab, they would still consider that everything is permissible and you need haram for an evidence. They may just differ in the phrasing of the maxim when it comes to, say, for example, sexual relations. They would say every sexual relation is haram except marriage, except what is halal. So they would say there the default is haram when it comes to sexual relations, because that's the norm, that's a general rule. Marriage is the only one that is permissible, so the rule is prohibition. So sometimes it's just how it is phrased, but in general, for mu'amalat, everything is permissible except what is prohibited. It's a number of prohibitions that would probably determine how the maxim is phrased, and Allah knows best.